Can business owners discriminate against gay people on religious grounds? By ducking that issue Monday in its ruling on a Colorado baker, the U.S. Supreme Court kicked the can down the road, straight to Kentucky. The state Supreme Court now will have to decide on its own whether a Lexington business violated the law when it refused to print a T-shirt for the city's annual Gay Pride Festival. Kentucky's High Court had delayed scheduling arguments in the case while it awaited what was expected to be a landmark decision on the rights of a Colorado baker to refuse to make a custom cake for a gay couple. But while the U.S. Supreme Court ruled for baker Jack Phillips in a 7-2 decision, it did so on narrow grounds, holding that the Colorado Civil Rights Commission had shown impermissible hostility toward his sincere religious beliefs. Earlier, gay pride T-shirt case will be heard by Kentucky Supreme Court-related gay marriage plaintiff. Supreme Court's cake ruling is un-American. Writing for the majority, Justice Anthony Kennedy said the outcome of other cases like this must await further elaboration in the courts, recognizing that these disputes must be resolved with tolerance, without hands-on originals, an emotionally wrought dispute that has attracted friend of the court briefs from 24 civil liberties and religious advocacy groups as well as Governor Matt Bevin. The case arose in March 2012 when a gay rights group known as the Pride Community Services Organization asked Hands-On Originals to print a T-shirt, and the company's owner, Blaine Adamson, refused, saying he had religious objections to the message, pride and being gay. The commission found the store had violated the city's Fairness Ordinance, part of which prohibits businesses open to the public from discriminating against people based on sexual orientation. Opinion: Kentucky valedictorian's speech too much for religion that favors silence. A circuit judge struck down the ruling, and in May 2017 the Kentucky Court of Appeals affirmed, holding 2-1 that the Fairness Ordinance didn't trump the company's right to free speech, including its right to refuse to promote a message it disagreed with. The commission appealed, and in October the state Supreme Court agreed to hear the dispute. Both sides took comfort in the U.S. Supreme Court decision. Luke Goodrich, vice president and senior counsel at the Washington-based Becket Fund for Religious Liberty, which filed a brief for the Lexington printer, said the Colorado case sends a clear message that the government can't treat religious objectors like second-class citizens. That's just what the government did in Hands-On Originals. Similarly, Lexington attorney Brian Bowman, who represents the company, said, just as the state of Colorado failed to respect Jack Phillips' beliefs, the Human Rights Commission failed to respect Blaine Adamson's. The Supreme Court's decision makes it even clearer that Blaine and his company, Hands-On Originals, should prevail in their case. Hostility toward people of faith has no place in a diverse society like ours, and Bevin's general counsel, Steve Pitt, said in a statement, while we are still reviewing the specifics of the Supreme Court's decision, this appears to be a big win for religious liberty and a strong indicator that Hands-On Originals will prevail in their case. But the executive director of the Human Rights Commission, Raymond Sexton, said while he was disappointed the court hadn't issued a broader ruling supporting gay rights, he was encouraged because the ruling didn't preclude that, in the future. Read this: gay candidate selection loss. More about local politics than Kim Davis. Also, iconic Louisville gay nightclub is being demolished for new hotel. It looks as if the Supreme Court has decided to kick this can down the road, he said. Other gay rights supporters, including Richard Katsky, legal director for Americans United for Separation of Church and State, which also filed a brief in the Lexington case, noted the opinion embraced anti-discrimination laws and said the Colorado agency was merely wrong in how it reached its decision. In its friend of the court brief on the T-shirt case, Bevin's office said that requiring the owners of Hands-On Originals to promote homosexuality would have violated their religious freedom and freedom of conscience guaranteed under the Kentucky Constitution. The Colorado case arose when David Mullins and Charlie Craig sought a wedding cake for their reception, and Phillips turned them down, saying he wouldn't use his skills to convey a message at odds with his religious faith. The Colorado Civil Rights Commission ruled for the couple, but the Supreme Court said some of its members showed an impermissible hostility toward Phillips' religious beliefs, disparaging his faith as despicable, and comparing his invocation of his sincerely held religious beliefs to defenses of slavery and the Holocaust. Andrew Wolfson, 502-582-7189, a Wolfson at courier-journal.com. Twitter, @AdWolfson, supports strong local journalism by subscribing today. www.courier-